Okay, so the first thing we're going to talk about is making copies. This is sort of the analog version of copyright violations. And it's still one that we get from time to time. For the most part, these are obviously a lot more difficult for a copyright holder to prove a violation, right? Because if you have consumable textbooks still, and that copyright holder has no idea really that you've made an extra copy for the kid who just optioned in before you were able to buy a copy from the company, it's hard for them to detect it. But nonetheless, this is really the basis of the copyright law. As you continue to digitize things like your textbooks, your workbooks, it's going to become easier to detect these things. So knowing when you can make copies for educational purposes is important. So this is the first in a series of hypos that we have. They're not all structured the same way, but what we're trying to do is hopefully highlight some of the most common questions that we get. So let's assume we have an English teacher who finds an article from the New York Times talking about the use of the Oxford comma.
And of course it would be about how you should not use the Oxford comma, because that's the only American way.
You can see why we use this hypo. And so what they want to do is it's an English teacher who says, you know what, here's some good arguments for why you should and shouldn't use it. Karen's obviously wrong. Let's distribute this article to the class and sort of get their input. So she makes an article or a copy of the article. She prints it off from her desktop, makes a copy for everybody else in the class. Has she violated copyright law? So to really get into this, you have to talk about individual liability theories. The interesting part of how this works is there is an initial assumption that the person, not the entity for whom they work, is the violator, right? Because you could have an intentional violation. Now, as Karen pointed out, for the most part, they're going to come back at the school even if they find a violation like this.
But the reason this information is important for you is when you take this back to your staff, you need to explain to them, because teachers will freak out when they hear this, that they can be liable personally for the full damages.
Right. Yeah, absolutely. And that's the initial presumption in the copyright law, is that each individual is tasked with understanding it. So there are individual defenses. Courts can suspend statutory damages or reduce them where the infringer had a reasonable grounds to believe that his or her use was a fair use, and that infringer was an employee or agent of a nonprofit education institution. This is one of several examples within the copyright laws where they actually talk about the significance of being a school employee. That's why we can't emphasize enough that we may not be able to tell you how exactly you should play background or warm-up music at your basketball games during this presentation, but we can tell you how you can avoid most of this, and that's having some system in place to do some amount of analysis so that you can always say, we had reasonable grounds to believe our use was either a fair use or in some other way not a violation. So the school liability theories, the first and the easiest one is contributory infringement. This is based on you saying to somebody, teacher walks in and says to principal, hey, new kid in my class, what am I supposed to do about being short a textbook or a workbook? Principal says, why don't you just run off copies until we can get one ordered? Unless that is authorized by your license from the textbook company, you have violated copyright. The contributory aspect of it is because you've had a principal, somebody who is able to direct or demand something be done, asks a staff member to violate copyright law. The school's not going to be able to get outside of that saying, well, the teacher should have known that the principal was wrong, because you as the school may have a contributory infringement violation because you encouraged somebody to do that. The key emphasis, though, is looking for the financial benefit. So in other words, if the idea is that, hey, I'm cheap, my superintendent is cheap, I don't want to pay for another 2 copyright protected workbooks, so instead just make copies, that's the financial benefit. There's a financial benefit to not paying for licenses for cartoons. So, hey, teacher, put together an in-service training for the rest of the staff and steal some of those really funny cartoons off the internet. You have decided, you've directed that person not to buy them. You said the school isn't going to pay for them. So in that case, you've received a financial benefit simply by not purchasing the license. But it requires some element of knowledge of the infringing activity.
Okay, so this Bosch case is kind of an interesting case. It's actually a case involving a medical school, not a K-12 school, but this Bosch got into hot water with her department chair. And basically he changed the locks on her office and said, forget you, we're not going to let you teach this class that you want to teach anymore. And so he changed the locks on her office, but then he had Ball Kell, who's the professor that's going to take her place, go into her office, get her teaching stuff off of her computer, and then just get ready to roll to teach the class that they're not going to let her teach anymore. Notice two things about this to begin with. One, the defendant is the individual, not the institution. So it's a good way to scare your staff, to remind them that they can be individually liable for what they steal. The problem was that the material that this teacher had put together for her course, she had done before she came to work for the university, and she had actually filed a copyright application with the Copyright Office to copyright her unique approach to teaching this part of medical school. So she files an infringement violation against the individual, but she doesn't really want money damages against the individual. She wants them against the institution. So the question is, can the college be liable for this Ball Kell going in and taking the stuff that Bosch owned? The school moved for summary judgment, said to the judge, hey, we should not get tagged for this, and the court denied it. It said, look, school, you were aware that your employee went in and took this teacher's teaching materials. You should have been aware that she'd copyrighted them, that you didn't own them. You authorized the photocopying of somebody else's stuff that they owned. You were aware that they were going to use it for your benefit, and you didn't do anything to stop her from using this other person's teaching materials. Now, 99 times out of 100, the curricular materials that your staff are using are owned by the school district. So I'm not worried about using somebody else's lesson plans. But if somebody has put together a great unit and then you photocopy that and use it for other people, you need to make sure that the stuff within that unit is also not copyright protected. Because then you can be held that you were contributorily infringing because you encouraged your teacher to steal stuff and use it. So that's contributory infringement. Is this one me too? Stop.
Nope, keep going.
You can also be vicariously liable if the other person has to prove, the plaintiff has to prove that it was direct infringement. You don't have to prove that you knew that the other person was responsible. And they can also impose liability on you if you get any financial benefit or if you have supervisory control. Again, what this slide is really meant to tell you is you need to train your staff on copyright, because you can get tagged as a school district for liability for your employees' violations, even if the employee is also sued as an individual. And it could be, you could not even know. The basketball picture, the school district didn't even know that somebody had put that on their website. It doesn't matter. The school district was vicariously liable because they should have kept track of what their employees and students were doing. Is this me? Yeah. Oh, yeah. So this is a student group that was showing an old film every year. And you can see the date of this case was 1972. And the film itself, I think, was made in the 1950s. And so the student union showed it every year. And they got a takedown notice every year. The student union thought they had a license. The question is the university responsible if they knew or should have known that this student group was having a fight with the holder of the copyright from the film? Before, every time they showed it, the student group said to the university, hey, remember, we're having this fight with the person that owns the rights to the movie. We think we have a license. In this case, the school won because the court said that although the university had the ability to control the use, they could not be held responsible for everything that the student group did. And the student group had given them notice that they had a reason to believe they had permission to use it. In this case, the university got off the hook. So here's what this tells you. If the PTO is having movie night, you can't just ignore the fact that there's potential copyright significance to that. You need to ask them, hey guys, do you have your act together? Do you have a license? Then if the PTO says yes, you're covered because you've made a reasonable inquiry and you had a reason to believe that they were doing it the right way. And in this case, the reason the university was not held liable is because they had those conversations. Even if you're wrong, even if the PTO lies to you, you now have an excuse to not be liable for their copyright violation. So the point of this is that you have to ask questions.
All right. Well, we're up to.
So while we get oriented, I do have a quick question on text. If a district purchased the public performance rights to a movie or song, do those rights apply if the PTA shows or plays that work at the school building? Nope. You are two separate legal entities. Now, you as a school can include the PTA or PTO in what your request is, but if your license is just for the school, that will not automatically cover your PTA. They are going to need their own public performance license. We're going to show you the place to go to, a way to get the license. I've done this for my own PTOs, and it's like $50. It's not terribly expensive.
All right, fair use is the monster defense, the monster exception that exists. And this is one where I talked about a little bit earlier. You get a 4-part test that we'll talk about here in a bit, and you think, well, this can't be too hard. Unfortunately, that's not true. But the number one piece we want you to take away from this is educational use does not equal fair use. And that seems to have been a common misconception of those who violate this law. But the fair use concept comes out because, as we said, we want people to have control over the content they create, but we don't want to have a blanket prohibition that prevents others from using at least some part of their work, because we want some of that information to be shared freely. It's just better off as a society. That's the decision that's been made. So fair use, it was an exception that was enacted in that 1976 Act and permits you to use copyrighted materials in ways otherwise that would have been infringing on the creator's rights. It is an affirmative defense, which essentially means if somebody comes after you, you have to raise it as a defense. And the burden of proof would be on you to prove that it was in fact a fair use. So the most common examples are criticism, comment, news reporting, teaching, that's our big one. Scholarship, research, and parody, that's where you get all those Saturday Night Live presentations that would seem to be a copyright violation. That's how they get away with it. So the reason this is kind of frustrating is you'll call to ask if this is a fair use, and our response is going to be, it depends. And the quote here kind of sums it up. Although the courts have considered and ruled upon the fair use doctrine over and over again, no real definition of the concept has ever emerged. So after all these years and all these cases, since 1790, we still don't have a real definition, a bright line rule for fair use. And since the doctrine is an equitable rule of reason, no generally applicable definition is possible. So they're saying they're never going to come up with one, is basically what they're telling us there. This comes from an attorney that represents the music industry. Fair use is the teachers and the performers and the lawyers' nightmare because there are no clear answers to almost anything. So it's kind of like pornography. You know it when you see it, one of those cases. And so Bobby will tell you all about those. So here's your 4-factor test. The purpose and character of use, including the nonprofit educational purposes. So obviously we have a leg up on everybody else because of that provision. The nature of the copyrighted work, the effect of the use on the potential market for the value of the work. That often works in our favor as well because, again, we're a nonprofit educational institution. We're not typically going to have a huge impact on the value of the work. And then the amount and substantiability of the portion used. So how much are we taking? That's going to be a huge part in many of these cases. All right, so here we have, what's this? This is Ms. Hazy.
Yeah, this is, the act does not tell us how much copying exactly we can do for teaching purposes. Back in the day, when I was teaching the school law course for UNO, I 100% violated Copyright Act because I would just take chapters out of the book I liked and then put it together in a big packet. We know that you cannot use photocopying in a way that undermines the market for the product, but it doesn't tell us exactly how much is too much, and that's it's difficult. There are guidelines on classroom copying for not-for-profit groups that are in the some of the material that we've included in the circular and on the website, and we'll buzz through some of these specific examples. So you can make a single copy by a teacher if it is for use in teaching in preparation for a class. You can do a chapter from a book, an article from a periodical, a short story or short poem, or a chart, graph, or diagram. But you can't replace a book by just copying chapters from a bunch of different books, if you see what I'm saying. You can use multiple copies, one per kid in the classroom. If it is for classroom discussion and if it's brief and spontaneous, if it doesn't meet the cumulative effect test, and each copy includes a notice of copyright. So this slide right here takes us back to the hypothetical that we're talking about. The teacher that makes the photocopy of the New York Times article. So this is a chance for me to check for understanding. Just in your brain, think, how would this slide answer the hypothetical we've given? And then we'll give you the right answer at the end.
And real quickly, the slides after Steve went through the fair use test, the 4-part fair use test, when you call us, that's what we're going to apply. The last couple of slides, and this slide in particular, talking about brevity, spontaneity, that's part of this circular document that we've attached, where essentially you had various groups from the industry come together when they updated this in the 70s and asked, okay, we got to provide some guidance to classroom teachers and librarians of how to do this. Otherwise, they're going to sit in their classroom and try to figure it out. So when Karen's going through the single and multiple copying, that comes straight from that Circular 21 document. So this is law to the extent that it's guidance from Congress, but understand when we talk about these next few parts, they are part of analyzing whether you get to use the circulars protection. They are not necessarily directly implicated by the fair use test itself. So it's kind of confusing, but yeah.
So you see here that we have the copying has to meet the brevity and spontaneity tests. The brevity test literally counts the number of words that you've copied. So if the poem is less than 250 words and it's not on more than 2 pages, you can copy it. If it's a longer poem, you can have an excerpt of not more than 250 words. And literally look at this footnote. They say, oh, yeah, but if you want to finish the last line, you can go over the 250 words to like make the thought complete. For prose, the brevity test says the complete article, if it's less than 2,500 words, that's about 10 pages. About a typewritten page has about 250 words on it, and I know that from being a speech coach.
But how many Oxford comments?
None, because it's well written in America, man. And you can have an excerpt from a prose work of not more than 1,000 words or 10% of the work, whichever is less. And again, you can say you can expand it to finish the unfinished line of the paragraph or thought. You can use one chart, graph, diagram, cartoon per book. As long as you're not taking the entirety of like if the entire point of it is one big illustration, you can't use it. But if it's a book that has a bunch of illustrations, you can use one picture from a book, and that's considered brief. And then spontaneity, the second thing that you have to ask about is it because the teacher just had this great idea, or did the principal tell her to do it? That undercuts the spontaneity. And it has to be close in time, like current events, or this article was in yesterday's paper and I thought it was really interesting. That's what you need to meet the spontaneity test.
Yeah, and you can't, what it says literally in the circular, because remember, this is the 70s, right? They're not thinking about emailing the copyright holder and getting a response back. They're thinking about like snail mailing a letter. Can I use this article? So what the circular says, and what I worry about in terms of the circular, probably my biggest concern, is it only allows you to use these classroom copying suggestions from Congress if it would not be reasonable to expect that you ask the copyright holder for permission.
In time, like there's no time.
Right, like I have to use this article right now. I can't wait 2 weeks for a snail mail to be exchanged. So when you're printing off something from NewYorkTimes.com, I think it's a little bit harder to make the argument. But so anyway, this is still in there. It's not that it's been read out, but I worry about how much easier it is to ask for permission nowadays when you can buy a license from the New York Times in a matter of seconds.
And then the courts will also look, or the circular also looks at what's the cumulative effect, right? If you're copying it for just one course, that probably does not have a cumulative effect. If it's limited to one short poem, article, or story for one class term, or 3 items from the same collective work for one class term, then that's not going to have the cumulative effect of, I guess the idea is that you wouldn't buy the whole book just for one poem, but if you're gonna copy 5 poems, then maybe you would go to the principal or the superintendent and ask them to buy the book. So the cumulative effect can't have the impact of, otherwise I would have bought the book if I couldn't have made these copies. You can have 9 instances of multiple copies for one course, and that doesn't apply to your current events classes. You can have more than that for news periodicals if you have a current events section of your class.
All right, the prohibitions, we'll go through these pretty quickly. One, they have a big hang up. As you'll see, it'll be a pattern. They don't want you creating anthologies, compilations, or collective works. There's prohibitions.
Which is what I did, totally, I confess.
Those are in several sections. They don't want you using consumables or copying the consumables, the workbooks, the standardized tests, things of that nature. That's a repeated provision. And they don't want you substituting copying for obviously the purchase of books. And so I think Bobby had talked about that earlier. When the science book isn't there, they don't want you to copy the entire book, even if you're going to purchase it later. So, and also when you do make copies, you can't charge students beyond. They don't want you making a profit on any copies that you do.
And I don't think you can charge students anyway, because I think that would be a student fee under the Student Fees Act, in addition to being a copyright violation.
So the answer to our hypo, the English teacher made that copy from the article, yesterday's article from the New York Times about the Oxford comma. Has she violated the copyright law? No. She's met the brevity test. She's met the spontaneity test, assuming, of course, that this was 2,500 words or less, which we probably should have put in there. But assuming it's a normal length article, then no, she wouldn't have violated any of the copyright
Yeah,
laws.
I think the only thing I'd be worried about is, number one, is the New York Times going to say you should have bought a subscription for every kid in the class. And you should have asked them for permission. That's that part of the spontaneity test. But I think for the most part now, we would take the position that this is acceptable.
Yeah, I think she's cool. I don't think she's violated the copyright.